Yes, counsel. Good morning.
Good morning. May it please the Court, my name is David Hartnagel. I'm an Assistant Attorney General, and I represent the Commonwealth in this matter. In this erroneous conviction brought by Mr. John Irwin under Chapter 258D, the Commonwealth respectfully requests that this Court reverse the lower court's two concurrently issued rulings, one, denying the Commonwealth's motion to dismiss, and two, granting the plaintiff's motion for partial judgment on the pleadings. Both motions and orders concern a single issue and a single underlying question: whether Mr. Irwin is eligible to pursue a claim against the Commonwealth under Chapter 258D's limited waiver of sovereign immunity. Now, in this action, Mr. Irwin is alleging that he was erroneously convicted in October 2005 out of Quincy District Court of indecent assault and battery on a minor, a conviction which was later reversed before the appeals court in September of 2008. As this Court is aware, Chapter 258D is a limited waiver of sovereign immunity against the Commonwealth that provides individuals who can satisfy certain specific eligibility criteria an opportunity to seek compensation from the Commonwealth. As a result, in turn, if an individual falls outside of these eligibility criteria, yes, Your Honor.
Finish your sentence.
If they fall outside of the eligibility criteria, then they would be barred from pursuing a claim against the Commonwealth as a result of the retention of sovereign immunity.
Well, I wonder if you could address the issue. Accept all that, but one of the requirements of the doctrine of present execution is that the matter be collateral to the underlying thing.
Yes, Your Honor.
One could argue here that what needs to be shown in order to fit within the eligible class and what ultimately gets proved are so interrelated that it is not collateral. I mean, that the facts of the case really matter for both, and therefore it truly isn't a collateral matter. And I wonder if you could address that.
Absolutely, Your Honor. The Commonwealth's position is that that the eligibility criteria, and specifically the issue here, which is whether the judicial relief reversing the felony conviction rests on grounds that tend to establish innocence, we would submit that that absolutely is a collateral matter to the ultimate merits of the controversy. The ultimate merits of the controversy at its core, at trial under Chapter 258D, is whether the plaintiff can prove affirmatively that he or she is actually innocent of the alleged crime. This particular aspect of the eligibility criteria simply looks at an analysis of the grounds reversing the particular conviction. In fact, this Court in Guzman and thereafter in Drumgold found that this is a question of law. As a result, we would submit that in every 258D case, it would be nearly impossible for this question to ever be a question of fact that would ultimately go to the jury. It's also because it's a question of law, and thus the Court can certainly determine it prior to trial. We would also submit that at a particular trial, the plaintiff, in proving their affirmative innocence with respect to the crime, would obviously bring in multiple grounds for why they may be innocent, multiple grounds that the appeals court or this particular court would never have considered in reversing the conviction. As a result, with respect to the eligibility criteria, this court, or any court for that matter, only needs to look at the exact language reversing the conviction, which is a distinct matter from can the plaintiff actually prove that they're in fact innocent. The ground upon which the reversal rests upon may never actually even be brought forward at an underlying trial, and thus we think that the matter is collateral and that the doctrine of present execution should in fact apply. Just to turn to that issue very, very quickly, we would submit that this particular statute, 258D, is actually analogous to the Chapter 258 Master of Claims Act, where you have limited waivers of sovereign immunity and individuals falling within and without. And we would actually even refer to the Court's most recent ruling in, I believe it's Shapiro versus the City of Worcester, where Chapter 258's doctrine of present execution application was reaffirmed. With respect to the underlying question of eligibility, again, in this particular case, Mr. Irwin's conviction was reversed by the appeals court on a single solitary ground. The appeals court—
it's a pretty important ground, though. Let's look at the trial. This is all about credibility.
Correct.
The defendant testifies.
Yes.
Others testify, called by the defendant.
Yes.
The complainant testifies on the other side.
Correct.
All about credibility.
Correct.
Is the defendant's story to be believed, or is the complainant's story to be believed? Right?
Generally,
and
yes.
The key issue in the case, at least according to the appeals court, swung the balance, perhaps.
Correct.
Was the misuse of evidence by the Commonwealth. that the Commonwealth argued an inference which was impermissible and without basis on the question of consciousness of guilt. So that really goes to who is to be believed.
That may be true, and certainly one of the issues is the fact that credibility was certainly a key issue in the Drumgold case decided 2 years ago, and one of only 2 cases that's ever interpreted this particular statute. But there's a key distinction, actually 2 key distinctions, between the credibility assessment that was necessary in Drumgold versus the credibility assessment that took place here. The first is the fact that in Drumgold there was clear exculpatory evidence that that was at issue. You had potential short-term memory loss by a key witness and potential promises and inducements to a government witness that was never disclosed. Here you have inculpatory evidence, where you have.
Why is this inculpatory? Doesn't the court say there's absolutely no basis to draw the inference that the failure to speak to police is consciousness of guilt? No basis.
No, but it was used for inculpatory reasons.
That's exactly correct, Your Honor. And I would also submit, one, the prosecution used it to indicate consciousness of guilt. And I believe the trial court specifically, though I'd have to go back and look at the exact opinion, indicated that no evidence had been brought forward to indicate any sort of consciousness of guilt. Certainly if the prosecution had been able to establish further reasons why the individual had not spoken to the police or had been able to use one of the exceptions, and then that could have been brought in. But the second key difference between the Drumgold and the Irwin case is the fact that in Drumgold, this is evidence that was never brought forth before the jury. And in fact, I believe it's in the last or second to last paragraph of the majority's opinion in Drumgold, in which the court specifically states that at the heart of the reversal of conviction is the fact that the jury in the underlying criminal case was forestalled from making a fully informed decision with respect to the individual's innocence or guilt, and specifically the credibility of the witnesses. That's not the case here.
Well, let's look, you've got this amicus brief,
Yes.
which terms this evidence to be false evidence. Let's assume it's a little bit of an overstatement, but let's assume that that was the case. The government produced false evidence bearing on the defendant's credibility. Different case? Credibility is at issue, and there's 2 different stories?
I would submit yes, potentially. It's certainly difficult to argue within a vacuum. We have to see exactly what is the particular falsehood. We would note that there's nothing within the appeals court opinion that indicates that Mr. Irwin's failure to speak to the police over a 4-month period was incorrect. There's no evidence, the evidence is that they made attempts, and then ultimately there was a 4-month lag before communication actually took place. I read the amicus brief as essentially attempting to state that this wasn't true. A false inculpatory evidence could potentially be a police officer who states, I saw the defendant commit the crime, but in fact he was lying, or another witness who was coerced. We would submit that in those particular cases, what in fact has not been put before the jury is the exculpatory evidence of the potential innocence of the individual. So if a witness was coerced and said, I saw the person commit the crime, but in fact a police officer had coerced him into making the testimony, we would submit that ultimately what the situation is there in that case is exculpatory evidence, the evidence of coercion, that had never been put before the jury. And thus, again, you fall back into a Guzman-Drumgold scenario.
So is one way of looking at the difference between the case, if I have them right. In Drumgold, the witnesses in question, the witness that was very ill and the other one, were key witnesses and the case was about identification, were key witnesses to identify the defendant as the one who shot.
Yes.
Whereas here, nothing related to the state, to whether the defendant did or didn't contact the police. It didn't go to the complainant's credibility at all.
That's absolutely correct. The key difference is that in Drumgold, you're looking at government witnesses whose credibility are being attacked, while in this particular case, it is in fact Mr. Irwin's credibility that was at issue. There's nothing with respect to the grounds upon which reversal were based had to do with the complainant's credibility. Certainly the lag of Mr. Irwin's speaking with the police goes to his particular credibility, not the victim's in this particular case. I would also ask the Court to look at the statutory language arguments that the Commonwealth has made. In particular, as we've described, this particular evidence was used as Justice Botsford described, as inculpatory evidence. The very definition of inculpatory evidence is evidence tending to show one's guilt or that they involvement in a crime or wrong. It would go against the very plain definition of the statute that a conviction must be reversed on grounds that tend to establish innocence, while here you have inculpatory evidence. Which is evidence, again, tending to show one's involvement in a particular crime.
I'm really having trouble with this. I don't understand how evidence that has no probative value can be said to be inculpatory evidence.
Well, the one thing I would also note is that to the extent that the court would accept the other arguments that this is essentially evidence of no value whatsoever, at the very least, that still doesn't rise to the level of grounds that tend to establish the innocence of the particular individual. In essence, it's a neuter.
Absent it, you know, I mean, you have a pure credibility contest.
You do, but...
And someone's saying that he didn't do this. So why is that not, you know, an innocence factor?
The one thing that we would note is at a certain point, and as the court has noted this again within Guzman and Drummond, the court, any court in looking at this eligibility criteria is barred from going beyond the grounds upon which the reversal was based.
But the reversal in this case was based on a whole panoply of missteps by the Commonwealth, including closing argument.
That's true.
That took advantage of evidence that was not probative and used it to establish guilt.
It wasn't just that it wasn't probative, it was also violative of the defendant's right against self-incrimination.
That's correct, Your Honor. But I think it's key in terms of, with respect to Justice Botsford's point, is again, looking at the statute, this court needs to look at Chapter 258D as, with respect to a harmonious reading of the entire statute. And Chapter 258D has a specific provision, Section 1F. Now, admittedly, it is a evidentiary trial provision that evidence that has been obtained in violation of constitutional rights can still be admitted.
That's not clear that it would include this evidence, because this was not just on constitutional grounds. It was also on common law evidentiary grounds. It was no good.
That's absolutely correct. But we would submit that the manner in which to read the statute, the fact that Section 1F has been included, we would submit that both the appeals court in Riley, as well as a number of trial courts that have ruled on this issue, that inclusion of that section is indicative of the fact that the legislative intent is to not allow for individuals whose convictions are overturned because of such evidence.
I'm having trouble figuring out how it is when we can look to another portion of the statute to understand the statute and when we can't. I mean, when we answered the question before about whether or not the doctrine of present execution applied, you basically said it's completely separable. Eligibility is completely separable from the merits. And now you say we construe the meaning of the statute in light of this other section, which has to do with trial.
Well, with respect to separating the collateral nature versus the merits, I mean, I do point to this Court's own opinion in Guzman indicating that it is a question of law. And as a result, at a trial on the merits, it would never actually reach that particular point.
So it's a question of all right, never mind.
Let me get back to the point that Justice Lenk was making a minute ago about the tendency of this evidence to establish innocence. This was a pure credibility battle. He said, she said. You're saying to us that it did not detract from the complainant's credibility.
That's correct.
Had it done so, it might have affected, it might have qualified as evidence that tended to support the innocence of the victim, innocence of the defendant. Isn't that right?
I think potentially yes.
So why doesn't that potential also attach to the testimony of the defendant? Here, it's not just any old witness that's saying he wasn't there. It's the defendant himself, and he's pitting his own credibility against the victims. And so why, when the appeals court says the jury essentially could have believed the defendant. They could have believed the defendant's protestations of innocence. Why doesn't that fit into 1B?
We would submit that it does not fit within 1B because the question of attacking the credibility of the defendant ultimately is not a question of innocence. It's a question of whether the jury would have been more likely to acquit the defendant or find him not guilty. It's a point that this Court made, in fact, I believe in Guzman, which is that there is a distinction between grounds that tend to establish innocence and grounds that tend to reduce the likelihood of a guilty verdict. And we would note the distinction that way.
Right.
Certainly,
It sort of goes to whether the Commonwealth can meet its burden of proof.
That's exactly correct. That's exactly correct. I see I'm out of time. Unless there are any other questions by the Court, the Commonwealth respectfully requests that the lower court's rulings are reversed and that Mr. Irwin be deemed to be not eligible to pursue his claim within the confines of Chapter 258D. Thank you.
Good morning, Your Honors. May it please the Court, my name is Robert Sinsheimer, and I represent Mr. Irwin. I think I must begin by respectfully stating that Mr. Irwin is absolutely and unequivocally innocent of a horrible crime, and what happened here was really, really awful. But I know that may sound a little like closing argument. I'm not asking you to take my word for it. All I'm asking you to do is to give me a chance to prove it. To 12 people who likely will detest child abuse, as we all do, and will likely not wish to give a nickel to an individual that they think even might have done anything so derogatory to the public interest.
Well, I mean, the problem you have, though, is the language of the statute, which doesn't say that all persons found not guilty may proceed to collect civil damages. It precisely limits the category to those who are granted judicial relief on grounds which tend to establish the innocence of the individual. The question is, what did the legislature mean when it limited the set of persons found not guilty to be able to make the same argument that you want to make?
Sure. And I mean, that's the technical legal point, but when we talk about eligibility, I just want a chance. Now, why do I meet the statute? I think it's pretty simple, and I think that some of the questions bore on that already. It's a credibility battle, but it's a little more than that. It's a case where there is evidence that the child victim had identified someone else. And as discovery, discovery's still ongoing. There's been no stay. So we're quite sure it's that other person. We're going to prove that. Now, what the appeals court opinion says, taken as a totality of the circumstances, basically is this. He might be innocent. We got to give him another chance. And I'm using colloquial language on purpose because the precise language of the opinion is quoted in my brief, and I'm sure you've all read it.
Well, they didn't say he might be innocent. They basically said he didn't get a fair trial.
Well, they said more than that. They did use the word innocence in one of the sentences, and they talked about the real possibility of innocence. And one of the things I think that Judge Broussard said, and I thought it was brilliant when he entered the order that we wish you to uphold, is that, look, no appellate court is ever going to say, gee, we're reversing because the guy might be innocent. They don't say it that way. Your Honors don't write that way. Your Honors have sat, some of you, on the appeals court, but even wherever, no appellate court says, gee, we're a super jury. That's not what they do. Every single decision requires some procedural basis for a reversal, ones that at least result in reversal. And again, if you look at the actual cases you've already decided, Drumgold and Guzman. Guzman was ineffective assistance. That was the technical basis upon which Guzman got a new trial. And I suggest that this case is far stronger than Guzman. Now, the distinction they draw, well, this is inculpatory, and so that makes it different from exculpatory. I respectfully suggest, and most respectfully, that's a lot of nonsense. Every case that's ever tried, the judge usually talks to the jury about the scales of justice. I think Your Honors have given that instruction from time to time. So you got a scale. Does it make any difference whether they put too much, they don't give you enough exculpatory evidence, or they pile on the, quote, inculpatory evidence? And I agree, Judge Cordy, maybe in the best light it's not inculpatory at all because it's false. But I'm conceding, as Judge Botsford asked, well, they used it as inculpatory, and that's the point. They piled on evidence they had absolutely no right to pile on, and the appeals court said this guy might be innocent. You can't do that. And he gets another shot. And then they looked at their evidence and they said, forget it.
Okay, let me ask you, let's imagine a slightly different situation. Okay, same case, let's imagine that there was a search warrant which obtained evidence which was corroborative of the alleged victim's allegations against your client, and it turns out that that search warrant was without probable cause and is suppressed. That, of course, that evidence would have affected the evaluation of the credibility of the alleged victim versus the defendant, much as this did. What's the result in terms of this statute? Does the fact that he was found not guilty because it turned out that there was inculpatory evidence which was suppressed because the search was without probable cause, does that mean that he proceeds on to this trial regarding innocence?
No. And I think that that's the classic paradigm where you look at the actual technical decision that resulted in reversal. It has nothing to do about that with actual innocence. It has to do with the rights and obligations that we all have pursuant to the Fourth Amendment of the United States Constitution. And that's why, frankly, I didn't really spend a whole lot of time briefing the question of present execution, because it seems to me that it didn't matter. And I don't mean I don't care about the administration of justice in the Commonwealth of Massachusetts. I mean that I didn't care for John Irwin, whether or not you guys heard it first or later. The simple fact of the matter is, in Drumgold, I believe it was, or in footnote 6, I think it was Guzman, I apologize, you listed some things that, might not create eligibility. And clearly, I think we all know that a Fourth Amendment reversal or a Fourth Amendment suppression is the exact reason that this clause was written into the statute. You can't get out on a technicality and then come back and claim you're innocent, plain English. That's not what we're alleging happened here.
But the problem you have here is this is in part an Article 12 suppression. The appeals court found in part that this evidence would not be admissible because it's in breach of the right against self-incrimination. It basically says because you didn't go to the police and talk to them, an inference can be made of guilt. And so why is that different from my example? I mean, one is Fourth Amendment, this is Article 12, but there's still ultimately suppression based on constitutional grounds.
Because, and this is why I was segued into present execution, because it does dovetail a little bit into the merits. Mr. Irwin proclaimed his innocence from day one. The case that was tried was about, is he guilty or is he innocent? Not is he constitutionally protected from the police, not is he a joint venture. He says, I am innocent, I am innocent. Whether it's a constitutional violation or not, they cheated. And in the way that they cheated, they affected his credibility so that his absolute and unequivocal claim of innocence was impacted. And when the appeals court took a look at it and said, you can't do that, that means he's eligible to bring that kind of case. If, remember, he's subsequently exonerated. They had a right to try him again. It's the subsequent exoneration combined with the appellate decision that clearly, as I read it, says, this isn't good. He must be innocent, or it must be, it's close enough. There's a substantial miscarriage of justice. The utilization of that standard alone, I suggest, and I argue that in writing, gets us a long way, even though it's a coincidence that it had to be.
That means every single case that gets reversed because there's a substantial risk of a miscarriage of justice, you get a new trial because the defendant claims his innocence? I mean, in almost every case of sexual assault, that is, not almost every, but that is often the $64,000 question. He said, she said.
Yeah, I understand that.
Did it happen or did it not?
And I'm not saying that every single case where there was a sexual assault acquittal would result in eligibility for, well, excuse me, it'd have to be a conviction and then a reversal. Many might, because remember, we're talking about a situation where if a person, and I hate to use what may be an old and sexist term, but just to keep it moving, time is so short. Someone cries rape, and it turns out that the other person is absolutely unequivocally innocent. I do think they would be eligible to file, if in fact they did time, the jury believes it, and so forth. But again, you've got to prove this case to a jury that's got the public purse strings first and foremost, I think, on their minds. I don't think these cases are that common. I think if, in fact, the goal of taking this case, and I understood this court accepted the case unilaterally under its powers to do so, is to take a close look at the statute and consider the administration of justice and how it's affected. You're not seeing a lot of these cases. I don't think that the floodgates have been opened, and I think to some extent, and part of the reason I started my argument the way I did is you do have to accept that a bar, as a functioning bar, there's a screening process. Just because a case is eligible doesn't mean someone's going to bring it. It involves time and it involves concern. But the eligibility requirement is intended to be a threshold requirement. That is clear from your decision in Drumgold. That is clear from your decision in Guzman. And obviously those are long and complicated cases. I've got 4 minutes left. I don't want to get into factual comparisons unless you ask questions, but it's in our brief. We're confident that this case is far stronger on the eligibility claim than either Drumgold or Guzman. I think if you look closely at the facts of those cases, you'll agree. I emphasize that Guzman, again, came back on ineffective assistance. And yet, ultimately, for eligibility of the statute purposes, Guzman was considered consistent with or tending to show innocence. Now, I've got 3 minutes left, and I didn't brief present execution, but if I may, I'd like to say a word about it, because I know the case is here. And since we briefed, there's been a conduct of the Commonwealth that's raised a concern, in my judgment, on the present execution issue, and that's this. The Commonwealth in this case, as discovery has gone on, has filed a second motion for summary judgment, which is pending as we speak. It's not in this technical record, but I ask you to take judicial notice.
The first one was a motion to dismiss, so it's...
This was a motion to dismiss. But, well, you're right. But it's a motion based on facts that all predated the litigation. It's not on the merits. It's based on the fact that Mr. Irwin accepted a probation violation, and they claim that that's an estoppel, and that means he must have been guilty. And we think we're going to beat that. That's not the point. The reason I'm raising it, nor am I critical of good litigators doing their job. The only reason I'm raising it is I don't like yo-yo litigation. And I suggest that this court shouldn't like yo-yo litigation. And I suggest that if you rule that this, in fact, is right on present execution, make some kind of rule that they got to bundle all their motions that would have been available to them prior to the inception of the litigation so we don't have to come back and forth. I'm sorry I didn't brief it, but it all happened after the fact. And as I said, my concern for John Irwin, who's my only client, is that he be allowed to have a trial. That's the only thing I'm here as his lawyer asking you to do. I raise the other in the interest of the administration of justice because it is a new statute and it is the facts of this case, and I hope you'll consider it. I'll answer any other questions. Thank you very much.
Thank you, counsel.